All right. Board of Appeal, 126th District of the State of Florida, down session, the Honorable Ann Traver, Chief Judge, presiding. All persons having business before the court, all near to the attention will be heard. And God save the United States of America, the State of Florida, and the Commonwealth of Florida.
Thank you, Marshall, and good morning, everybody. Welcome to an oral argument session of the Sixth District Court of Appeal. This session is being streamed live on YouTube. If you haven't already silenced your cell phones, we'd be grateful if you did so. We have one case on the docket this morning. It is case number 23-310, the state of Florida versus Alvin Vianney Freeman III. Let me first introduce the rest of the panel before we get started. Seated to my right is the Honorable Carrie Ann Wozniak, and to my left is the Honorable Keith White. The appellant will have 5 minutes if you don't tell me otherwise. If you would like more than that time, then please let me know. No proceed. Oh, I have you guys in different seats. My bad.
May it please the court, I'd like to reserve 5 minutes for rebuttal.
Yes, ma'am.
And good morning.
Good morning.
It's the state's position that the trial court erred in granting the motion to suppress in this case. And that the trial court failed to give the required deference to the magistrate's determined probable cause in this case. The state's position is that the affidavit supporting search warrant provided sufficient facts establishing a fair probability that evidence of crimes of attempted murder and or felon in possession of a firearm would be found at Freeman's residence. By focusing on what was left out of the affidavit, the trial court incorrectly discounted what was within the four corners of the affidavit. And this was the only information that the issuing judge had to consider, and the only information which the trial court was to consider in this case. And this court's task is to review the trial court's ruling regarding whether the issuing magistrate made a proper probable cause determination prior to issuing a search warrant. And therefore, our standard review is de novo. And the duty of a reviewing court is simply to ensure that the magistrate had substantial basis for concluding that probable cause existed. And this is under Illinois v. Gates of the United States Supreme Court.
What was the probable cause to search for cell phones?
Well, there is, in looking back through in preparing for oral arguments, I did notice that in addition to what I had said in my brief, the common sense that criminals use phones and computers in conducting their crimes. And the controlled conversation on November 6th, here says Williams stated the victims were in an apartment. When asked if he'd seen them, Williams stated, no, we were called. And so that would indicate to me they were waiting. What they were doing, they were waiting somewhere near the apartment complex. We're told, and well, they were told they were going to be in the apartment complex and waiting, and waited for them to come out essentially and leave in their vehicle, and then shot at the vehicle multiple times with at least 2 separate weapons. So that would be the probable cause within the affidavit to indicate that they used phones and the commission of this crime. And again, there's 2 crimes here. We have attempted murder for shooting into the vehicle, and we also have a felon in possession of a firearm because Mr. Freeman is a convicted felon who should not be in possession of firearm. So our position here is that the facts within the 4 corners of the affidavit were sufficient to establish probable cause in this case. And again, the trial court, in determining that they weren't, did not give proper deference to the magistrate's finding of probable cause, and picked apart the affidavit on things that were not in the affidavit, instead of focusing on all the information that was in there, which was considerable information. We had the victims, statements to the officer. The officer conducted an investigation after being called to the scene of the shooting, where this vehicle had been shot, leaving the apartment building numerous times. I think there was like 20, there was a number of, I don't remember the number, but multiple bullet holes in the car, casings on the ground. The victim managed to drive himself to the hospital. The officer investigated the witnesses, the victims at the hospital. Mr. Robinson, who was injured, wasn't able to provide a statement, but one of the passengers, Keshan, first name was Keshan, had,
Sound.
yeah, she provided statements that she'd seen shooters. She couldn't identify them, granted. But she did say that one of them was holding a long gun. They also talked to Mr. Johnson, who was in the vehicle. He proceeded an investigation. They conducted controlled calls, which I previously mentioned. An inmate had contacted them with information for cases. Mr. Ronnie Turner, he knew Mr. Freeman.
Going to the different informants that are in the affidavit, you've got one, which is the jailhouse informant, who's identified by name and whose veracity is attested to. The second CI, we have some form of conversation. We don't know what type of form of conversation, whether, for example, it was just a CI doing straight hearsay, or whether he or she wore a wire. We don't have that person identified, and we don't have an attestation as it relates to veracity. How do we compare and contrast those two as it relates to being the probable cause? Obviously, one is stronger than the other. What's the floor?
Excuse me.
What's the floor? What's the minimum? Where is obviously the trial court, there was something about, I would assume maybe both, but
Well,
certainly one.
I think also, I mean, you have to consider the informants, Mr. Curtis Robinson, excuse me, Ronnie Turner, who is the one who is the incarcerated defendant. I mean, incarcerated person. He wasn't a defendant in this case. Perfect.
He's in jail.
He's in jail.
Yeah.
But he had been someone that the officer or detective had said that he had used before, and the information he had given was verified to be true. I mean, granted, that is a brief statement, but that is a statement of reliability, veracity of that defendant. And a state's position that the affidavit says we conducted a controlled conversation. And I believe when reading this affidavit, this in a common sense interpretation and context of this investigation is a controlled conversation, and that indicates that it was being monitored by law enforcement. Granted, that does not specifically say that.
Like what connects Mr. Freeman, like we're looking at the affidavit, it seems what specifically connects Mr. Freeman to the attempted homicide is the confidential informant statement conversations with Mr. Williams. Is that a fair statement?
That's a fair statement that would connect him to the attempted homicide, because he is specifically named by Mr. Williams as one of the shooters in I think the second controlled conversation. Also, we have to remember,
What else is there connecting Mr. Freeman to the attempted homicide?
well, there are puzzle pieces that indicating that he has guns, and we also have to remember there are two charges here. It's not just attempted murder, it's felon in possession, and he is a convicted felon. He should not have firearms. So we have Mr. Freeman being named by the Mr. Williams in the controlled conversation. We have indications from another person that the detective interviewed that the detective was investigating a separate crime. And Mr. Robinson told him that Freeman had, and there's some, granted some grammatical errors here, but I think in context, we can say that Mr. Freeman gave Mr. Robinson a gun. He said an AK-47 and the parking lot of Club Gossip, and that Robinson took it to Freeman's residence. So this connects guns to Freeman, the convicted felon, and his residence, as well as the statements of Ronnie Turner, who also knows him as a fellow member of this blood gang, knows his habits, and knows that he keeps firearms on his person, in his house, or under his house, and that he likes to keep them kind of as trophies of his crimes. So that puts Freeman connected to the homicide, but also connected to possessing firearms and having them be located in his residence. And they know it's his residence because that's his official probation residence, because he's on probation. And that is in the affidavit, and that the detective actually surveilled the residence. He knew that that's where he lived, and he also surveilled it and saw Freeman there the day before. So we have, Freeman lives at this residence, and we have the connection of firearms possibly used in this crime at his residence. And what we have to show is a fair probability that what they're looking for, the firearms, the phones, communication devices, would be located in his residence. And it's a safe position that this affidavit was sufficient, and that the trial court did not err in determining there was probable cause to issue the warrant.
Can you address the good faith exception, assuming we were to agree with the trial court that the affidavit was insufficient?
Yes, Your Honor. It's the state's position that the trial court misapplied Leon's a good faith exception, and this is indicated in the it's the concluding paragraph, where she finds that because the affidavit failed to establish probable cause, it precluded the application of Leon. Well, this is not this is not a correct statement of what Leon stands for. Otherwise, Leon would be meaningless. Leon is a good faith exception for a case when you don't have probable cause. And this seems to be propagated by some quotes that keep getting re-quoted from the second district, from one case, Garcia, and then it keeps, getting quoted again, and it's just an incorrect meaning of Leon's good faith. And here we think to determine, Leon finds that to determine whether they acted in good faith, you have to ask, would a reasonably well-trained officer have known that the search was illegal despite the judge's authorization? And here we have a very thorough, an affidavit thoroughly documenting an officer's investigation. This is not a bare bones affidavit. This is not an affidavit that's so lacking in indicia of probable cause that a reasonable officer would not rely on it. There's no showing the detective was dishonest or reckless in preparing the affidavit, and the trial court, there's no showing the trial court was misled by false information. Here, there was sufficient evidence to create disagreement between two reasonable judges and between appellate attorneys here. And I believe that under that standard, a reasonably well-trained officer would not have, if there was a finding there was no probable cause here, there's no reason to say that a reasonably well-trained officer would have known that search was illegal despite the judge's authorization and issuance of the search warrant.
Thank you.
If you have no further questions this time, I'll reserve the rest of my time for rebuttal.
Yes, ma'am. Counselor.
Good morning, Chief Judge Traver, Judges Wozniak and White. My name is Jason Blank and I represent the appellee in this matter, Alvin Freeman. The trial court correctly granted the motion to suppress in this matter, and this court should affirm the trial court's ruling. At the outset, I think it's important that we both discuss and clarify what the standard of review is, both for the trial court in doing its job and reviewing the magistrating officials' determination of probable cause, as well as this court's review of that trial court. The state is correct that the initial standard of review is one which gives great deference to the reviewing court, but that has a very specific definition outlined by Gates and cited and quoted by Rabb, which is cited in both briefs before the court in this case. One thing, however, that was left out of the government's initial brief in quoting the Gates discussion about what great deference is the mandate or the inclusion of the factors establishing the veracity and personal knowledge of the facts attested to by informants when they are not otherwise determined to be unquestionably honest citizens. That's language taken directly from Gates that was left out of the initial brief, and that is cited and quoted in multiple cases in the Appellee's brief.
But Gates doesn't involve the good faith exception, correct?
I'm sorry, Gates does not involve, correct, Judge.
In
Gates-
fact, they apologized to the parties that originally they had authorized and asked for briefing on whether the exclusionary rule should be modified, and they decided not to do that, right?
I don't want to get that much into the details of Gates because I'm not that familiar in what the court was apologizing for or not, but you are correct. It does not deal with the good faith exception. And what I would say, Judge White, is that that Gates is not on all fours for the purposes of this court's consideration today. And the reason why is, well, before I even get into the reason why, because I certainly want to talk about that, let's just acknowledge that this court, in reviewing the trial court's opinion, needs to presume the trial court's ruling is correct. That's the standard of review. In giving great deference to the trial court's finding as to probable cause or the lack thereof in suppressing the warrant, this court has to start. The floor of that standard of review is that the trial court's ruling is correct, barring an abuse of discretion.
Does that apply when the trial court is reviewing previous probable cause determination by another judge?
It does not, because there's, well, to some extent, the great deference standard of review does apply. The great deference standard of review applies to the trial court's review of a magistrating official granting probable cause. So to the extent that that great deference must be given to the lower magistrate, the lower judicial officer.
Sure, but it's talking about us. You've got a situation below where no evidence was taken, where there was basically a probable cause determination by everybody's agreement. You know, the circuit judge, the state and defense below, that basically said, we're not entertaining any witnesses here. I'm just going to look at the four corners of the affidavit. How are we differently postured?
You're differently postured because not only does this court, Chief Judge, have more information by way of the record in the trial court's hearing on the motion to suppress, but this court is also in a different position because you are empowered to do a de novo review of the legal findings.
Right.
Of the
So we
trial.
got to the same place.
Correct.
Yeah.
So
Okay.
there is a de novo review as to the legal determinations in the trial court, but as the factual determinations, which are key for this court's review, you are, as the reviewing body, to give great deference and to have a presumption that the trial court made a correct determination as the factual findings. That matters because the cases of Dial and Roper control as to what facts and information must be included inside of the affidavit in order to allow the reviewing officer the totality of the circumstances
Right. But
necessary.
that either meets the legal standard of probable cause or it doesn't.
Correct.
Yeah.
And, yes, but I think it's important for us to note that because it's a clearly established principle, but it's left out, and it is the crux of the trial court's problem with the affidavit in this case.
Well, let me ask you this, just as it relates to the two different offenses that are asserted in the PC affidavit. You've got attempted homicide and you've got possession of firearm by a convicted felon. And I asked your colleague about the differing levels of connection to your client as it related to attempted homicide. I kind of didn't really ask about possession of firearm by a convicted felon because that's where she went in her answer. But are you asserting that there's no probable cause in this affidavit for the search warrant to be executed as it related to the charge of possession of firearm by a convicted felon?
Yes. And
Okay,
you're
help
on,
me with that, because I think you'd have to concede that your client was a convicted felon, correct? Based on the four corners of the affidavit.
I would concede that at the time the affidavit was sought and that the warrant was issued, my client was a convicted felon. I don't think that there's any way I can dispute that.
Right, so the other element of that offense is going to be possession, and you've got the statement that he was in possession of an AK-47. And then you've got the statement from a fellow gang member who's identified and whose veracity is attested for by the affiant, saying that he keeps guns at a very specific location of his property. So I don't know if I'm missing anything other than that, but I think that that it kind of encapsulates what the reviewing magistrate was looking at as it related to that possession.
I would agree to a certain extent. However, I would challenge the court's factual determinations as to the fact as to whether or the straightforward attestation of the veracity of Mr. Turner, the convicted felon who is an alleged or seemingly known gang member. Again, these are the finer facts that were left out of the affidavit, which would give the reviewing magistrate a true totality of the circumstances. Additionally,
What if that was left out though? Like, because I don't want to be misstating the record, because when I think that I'm looking at the four corners of it, there's a representation that they were gang members together. There's a representation that he used guns in connection with crimes, and that he kept them at a specific place in his property. And there's a representation from the affiant that your client was a convicted felon.
you're correct on all of those points.
Okay, great. I don't want to be wrong about that.
No, you're 100% correct on what was stated in the affidavit. The issue arises in the corroboration of those facts. There was no further information to state that he was an established gang member. It simply says he was a gang member along with Mr. Freeman. It was never stated, there's no information contained in the affidavit that says Mr. Freeman was previously convicted of this gang offense or has been deemed a gang member. Nothing in the affidavit which says Mr. Turner has been previously deemed a gang member. It simply says they are gang members together. Normally, common sense and the implication would be, well, that's enough. But in this situation, we are dealing with a heightened standard of review. And that heightened standard of review in these types of informants, because they are not deemed or declared to be unquestionably honest citizens, demands that the specific information pertaining to their veracity and their basis of personal knowledge be included in the affidavit. And that's why
But what requires that? Certainly the text of the Fourth Amendment doesn't require that. So what Supreme Court case from the United States Supreme Court requires that?
it does not. However, the cases of Dial out of the fourth and Roper out of, I believe, the fifth control, because in the state of Florida, the Supreme Court of Florida has stated that Florida courts may enact and establish greater enhancements of the Fourth Amendment protections and Article 1, Section 12 protections against unreasonable search and seizures beyond that established by the Supreme Court of the United States. So Dial and Roper goes further.
How is that possible in the face of the conformity clause?
Sure. So what you see, Your Honor, is, and
I see you cited the Lavazzoli case
Yes.
from Florida, 1983, and you quote, free to provide its citizens with a higher standard of protection from governmental intrusion than that afforded by the federal Constitution. But that immediately follows the statement, in the absence of this amendment. And after a discussion of a retroactivity analysis, which they said, we're not going to apply it retroactively. And so therefore, we're going to apply the law that existed prior to the approval by the voters of the amendment and allow the exclusion of the evidence.
And at that time, that was appropriate for that specific finding. However, the premise that Florida may enact more stringent protections for its citizens still remains true. That's not dicta. And our position is
How
that,
can it remain true?
I'm sorry, Judge.
How can it remain true when the conformity clause specifically says shall be construed in conformity with the Fourth Amendment of the United States Constitution as interpreted by the United States Supreme Court? And then it goes on, it says, articles or information obtained in violation of this right shall not be admissible in evidence if such articles or information would be inadmissible under decisions of the United States Supreme Court construing the Fourth Amendment of the United States Constitution, not decisions of the Florida Supreme Court, not decisions of us, not decisions of other DCAs in this state.
Dial and Roper are not at odds with that finding. Dial and Roper are not infringing upon the Fourth Amendment to the United States Constitution. Dial and Roper are saying, once you meet the Fourth Amendment protections in the Article 1, Section 12 protection of the Florida Constitution, we can go further. And in situations here, that's exactly what this court should look to. This court needs to review the information below in the trial court's ruling. And Chief Judge Traver, you made a very key point in discussing, and I want to go back briefly in also answering Judge White's question, but I want to go back briefly to the discussion about how you kind of pit Mr. Turner's testimony with the confidential informant's testimony. And you made a key distinction. You said that in the trial court, something about maybe both, certainly one, rose some concern, I believe was the end of that statement. I'm sorry, I couldn't write it down fast enough. And that's exactly the issue. That's exactly the issue that we have. Is the trial court said, there are problems here. And let me be very clear. I do not dispute, and we are not disputing that the totality of the circumstances is the appropriate look for the trial court to take at the magistrating official's review. We do not dispute that the great deference needs to be given to the lower courts in its review. What we assert here is that before a reviewing court, whether it be this court, the trial court, or the magistrating official, can look at this with the totality of the circumstances viewpoint, it must have all the information necessary. It was not provided by the affiant in the affidavit, and Dial and Roper demand that it be such, so that the proper review can be taken to determine whether or not.
Certainly, I'd agree with you that there is less information and missing information as it relates to the confidential, the unidentified confidential informant, their name, how it was done, whether or not that there was any veracity. I think I was trying to highlight the contrast between the two as it related to possession of firearms by a convicted felon.
If I can address that, certainly. And I think that that's key. And that really speaks to the confidential informant as well as Mr. Robinson's testimony, Mr. Freeman's uncle, because the government noted in its argument just a moment ago that it was the testimony of Mr. Robinson that places a supposed AK-47 in the hands of Mr. Freeman. And that certainly would be the concern for the chief judge. However, it's again, the lacking corroborating information. And what the trial court noted was timeline, time frame, further evidence to establish when that occurred that prevents the information being able to be considered by the reviewing court.
What does
we don't
matter,
know
though, when he had it, if he was a convicted felon?
because we don't know if he was a convicted felon at the time he had it.
That sounds like a jury question on whether there's beyond a reasonable doubt. We're here on probable cause.
We are here on probable cause. However, in order to make a probable cause finding, the trial court has to have the information before it and available to be able to make that determination. As far as whether or not the person was convicted at the time or whether he actually possessed the firearm, those are questions for a jury. But when making a probable cause determination, the trial court or reviewing magistrate still needs to determine whether these hearsay statements by a person who has been deemed to not be an unquestionably honest citizen, whether that person has the veracity for the truth, potential motive to lie against the defendant or person of whom the search is being sought, or whether they have a proper basis of personal knowledge. Those factors are missing throughout, and in various forms, throughout the affidavit. As to Mr. Turner, again, and Chief Judge Traver, you noted both to my co-counsel, to myself, that Mr. Turner, who's the incarcerated informant that the detective spoke with, that it was attested to that he has veracity. I would challenge that assertion. A statement by a law enforcement officer in and of itself that this person is telling the truth, we would argue is not enough. We would say that that is not enough to satisfy the requirements under Dial and Roper, which does not conflict with the requirements under Gates of the United States Supreme Court. We think that we need something more. Maybe how many times that detective has worked with that informant, that person.
We said every time, right?
Well,
So it means more than once.
could be.
Well, I mean, if we just read the four corners of it,
Sure.
I guess you're right. I suppose every time could mean that the one time that I did it, but that's not how typically people would speak.
I don't disagree. And I understand that we look to the trial courts and the reviewing courts to have a common sense approach. I understand that.
Are you kind of like gearing towards the idea that we might need multiple affiants?
I'm gearing towards the idea that whenever a law enforcement officer, especially an experienced detective such as this, submits an affidavit to a reviewing magistrate to say, here's enough for you to make a probable cause determination, they know that they have to include enough corroborating information to prove the veracity and personal basis of personal knowledge.
Can I switch gears on you? Because I think I understand your argument as it relates to that. What evidence of law enforcement misconduct is there in this affidavit?
Judge, I think that if you'd allow me to shift the question, I think the question really needs to be asked as to whether or not there needs to be evidence of law enforcement misconduct.
So answer my question first and then explain to me why, because I think your answer has to be no.
It is.
And then just explain to me why that is then irrelevant.
That would have been the better appellate argument way to do it, is say none, Judge, however.
Thank you.
So let me say none, Judge, however. It's not incumbent on the defendant to say that there is misconduct. Our position is that when in a situation where a reviewing court is given a set of facts and circumstances with witnesses which require a heightened level of scrutiny, it is incumbent on the officer to provide that information, whether by negligence or intentional omission.
I think I was getting more to the good faith exception.
Well, and I'm going to get there.
Okay.
Whether it's by negligence or intentional omission, it's when that information is not included in the affidavit, they cannot then fall back and say, oops, but I'm relying on good faith because a judge signed off. And that's essentially what the state is asking this court to hold here, is that to say that a well-respected, experienced detective failed to include information he should have known should have been in there.
But isn't
And that
that the
the-
whole, like, and maybe I just might have a misconception of Leon in the good faith exception. Are you suggesting that Garcia had it right, that if you're missing probable cause in the underlying affidavit, that you can't exercise the good faith exception?
Yes. And I'm saying that Leon, it does not apply because Florida's heightened standard regarding informants that are not unquestionably honest citizens does. And Leon deals with a situation of an unquestionably honest citizen. So our position is that Leon is not on all fours for the case before the court today. So
we are to affirm based on a district court of appeal opinion in the face of the conformity clause in our Constitution approved by Florida voters that says only if the Supreme Court says it's inadmissible should it be inadmissible.
I would argue that Judge White, yes, I would argue that yes, the District Court of Appeal opinions control and are binding precedent upon this court, and that the conformity clause issue that Your Honor is raising
So
is
we're kind
inapplicable.
of, we're our court. So we're the 6th DCA.
That's correct.
And there's no horizontal precedent between DCAs, like just because the 2nd DCA has said something or the 1st DCA. Let me pose it to you this way. What do we do as it relates to McGill in the 5th and Wingate in the 1st?
So Wingate,
Which of those 3 DCAs bind us?
well, I think that until there is a conflict, and I don't believe that there is a direct conflict, and we could talk a little bit more about that. But until there is a conflict and until this court makes a specific finding on that issue, this court is bound by the DCA opinions of other DCAs as binding precedent.
What's your authority for that?
Judge, you're going to have to forgive me. I don't have the site. I'm happy to provide it.
So I have a contra
But there
authority.
is,
I have contra authority for that,
Sure.
whatever it might be. So the Pardo decision from 1979, 1980. Anyway, Florida Supreme Court
Right.
says that DCA decisions aren't binding on one another.
and certainly that it's within the purview of this court to rule however your honors find the law.
But I think the challenge for us would be, and I think for any DCA as it relates to the binding nature of it, it seems like that's where you're angling at is what the Supreme Court does in terms of settling interdistrict conflicts. So if you have the 2nd DCA and the 5th DCA disagreeing, they have jurisdiction to fix that.
That's correct.
But I don't necessarily know, for example, if the 4th DCA and 1st DCA said different things. Or in this case, the 1st DCA, the 2nd DCA, and the 5th DCA, like we're not their Supreme Court.
Sure,
Right?
and so we would argue to the court today that you should adopt the holdings in Dial and Roper, apply that standard as it applies to the good faith exception. And I would also argue to the court that Wingate actually is very instructive here, because Wingate talks about a bare bones affidavit, and in that situation, they talk about where it's just a circumstance such as I know this person's a convicted felon. He's a bad guy. He's selling drugs. Somebody told me, let's get a warrant. That's kind of what Wingate contemplates as a bare bones affidavit. We would argue that the bare bones, in quotes, terminology as used in Wingate also applies here, because the information required by Dial and Roper of the heightened scrutiny of the 3 key witnesses, and there were other witnesses in the affidavit, as we're all aware, but the 3 key witnesses, Robinson, Turner, and the unnamed CI, fail to have any information in one way or another dealing with veracity and their basis of personal knowledge. And because those pieces are missing, it should constitute essentially a bare bones affidavit. The reviewing magistrate did not have the information necessary to make a proper probable cause determination. The trial court identified that as an issue, properly granted the motion to suppress. I do see that my time is running low, so I just want to note one more thing and then quickly conclude. The proper course of action, looking back, which is not necessarily what we're bound to do, but the initial reviewing magistrate should have gone back to the law enforcement officer and said, there's not enough here. Let's be clear. That's what should have happened. That's how the system is designed. The initial magistrating judge, Judge Hill, should have said, we're missing these aspects of veracity and basis of personal knowledge. Detective, get me more and bring it back to me. That's what should have happened. It didn't. So we would ask this court to, I think the court's well informed on the issues. We'd ask this court to affirm the lower court's granting of the motion to suppress and affirm this matter. Thank you, counsel.
May it please the court. First of all, I'd like to address, I guess, the reliance on Dial and Roper. Dial and Roper, both cases are readily distinguishable from instant case. And those cases, both of them similarly, Roper, it was a case where there was a single witness who came forward, who had come to the police station to file a battery complaint against the defendant, who was her live-in boyfriend, or she'd been living with him for a while. And in addition to the battery affidavit, she executed an affidavit regarding drugs that we found at Roper's residence. And she was the only informant in the affidavit. There was no independent investigation. They just relied on her word and didn't put in the fact that she had come to the police station to report battery against the same man she was filling out the affidavit for drugs. And so they found there was no showing of reliability, veracity in the affidavit, and the affidavit was bereft of facts that could be fitted neatly together to comprise the totality of circumstances. And Dial is similar. It's similarly distinguishable. In that case, it was a defendant who it was the daughter of the defendant, and she had accused him of abuse. And then she swore an affidavit or gave statements saying that I think he had drugs in the home. I can't remember if his drugs or pornography, I'm sorry, but some contraband of some kind. So this case is distinguishable, those cases they found, these were just under the totality of circumstances, did not establish probable cause, and they had no corroborating circumstances or veracity of the two complaining people. In this case, we have multiple witnesses. We have forensic evidence of the shooting. We have a controlled conversation. We have statements of Curtis Robinson, Ronnie Turner, surveillance placing him at the home. This is not just one witness, an affidavit. It's on one witness who has some sort of a grudge against the defendant. So these cases are distinguishable. I don't see that we can rely on them to overcome Gates and or Leon. I'm not sure quite where that was going, but Gates requires that we consider totality of circumstances. And the state would submit in this case, although one statement left alone might not have been enough, when you consider this affidavit in context, you consider the totality of circumstances, you put the pieces of the puzzle together, and you have probable cause. So the state's position that this affidavit supplied probable cause, and that the magistrate was correct and the trial court was incorrect in determining that it did not. Also, it addressed the conformity clause. This court is not bound by Dial and Roper. This court must follow the United States Supreme Court on these Fourth Amendment issues. In these cases that are relevant here are Leon and Gates. And you must consider the Fourth Amendment issues in conformity with the United States Supreme Court's opinions on the Fourth Amendment, and unless it was a case where there was no Fourth Amendment, opinion on that type of Fourth Amendment. But of course, there is in this case. We have Leon and Gates. So the state would say that, again, the affidavit supporting the search warrant provides sufficient facts establishing a fair probability that the evidence of crimes of attempted murder and or felon possession would be found at Freeman's residence. And by focusing on what was left out of the affidavit, the trial court incorrectly discounted what was within the four corners of the affidavit, which was the only information the issuing judge had to consider, and the information that sufficiently established probable cause. We would also say that if in case this court would find that the trial court was correct in finding there was no probable cause, and the good faith exception could apply. Even if the affidavit was insufficient and failed to establish probable cause, the trial court misapplied Leon, because Leon does not say you can't have good faith if you have no probable cause. Again, as I said earlier, otherwise Leon would make no sense. In this case, there was no evidence of misconduct, which was not a bare bones affidavit. And this is not a case where there were no indicia of probable cause. And Garcia is not correct recitation of the law. If this court has no further questions, I would ask that you reverse this, the trial court's the not granting of the motion to suppress and remand for further proceedings.
Thank you. Thank you both for your presentation. And we will be in recess.